So once again, hello from Santa Barbara County, SELPA. We have the amazing Jan Tomsky, our dear friend here from Fagan, Friedman, and Full Frost. Jan, gosh, it's been 6 years that I've known you, which is amazing. And isn't that amazing?
Well,
Uh,
I remember how much fun it was originally when we would actually do this in person, and
yes.
it was great.
We want to get you back here in person. We love that. So, again, I just want to say thank you so much for coming. And for those of you that are here today, thank you for giving your time for this training in hot topics in special education. So, Jan, I'm going to advance us forward to our next slide.
Okay. Um, and and as always, before we kind of leap into our what is turning out to be a twice yearly conversation about issues that are going on, the legal perspective on those issues and things that have come up in the Santa Barbara County SELPA, and then from my perspective, things that I'm seeing throughout the state and even beyond. Um, Jennifer helped me focus on some issues that perhaps have been coming up for you, just some questions that might have arisen. One of them being around surrogate parents. What are the requirements? What are the obligations? And what are the parameters of surrogate parents being involved in the IEP process? So thought we would just touch on the legal framework for that to give us some perspective, and happy to entertain any thoughts or questions because there, there can be issues that are fuzzy and lines that aren't entirely clear around involving parents who have been appointed as surrogates in the IEP process. So happy to discuss it. Um, Frustrations continue to exist related to the California Department of Education's um, requirements related to service tracking. We had talked about that some time ago, but I just kind of wanted to revisit, maybe not to answer all of your questions or even any of them, but at least sort of remind us where this all comes from, why this process exists as it does, what the pressures are on the California Department of Education, and where it may all be going for us. Wanted to talk a bit too about adult students, and one of the issues that Jennifer mentioned to me that's come up is one that, comes up kind of routinely, particularly, and I don't know of those of you who are here today who works generally with older students, and particularly students in our adult transition programs, who tend to be students who are pretty significantly impacted, students who have not been on the diploma track, whom we intend to serve until they're 22, but even some younger students who become adults while they're in high school, and their rights have transferred. But what are we to do, particularly when concerned about whether those students as young adults really are competent and capable of making educational decisions, which the law now has shifted that obligation to them, and what are some options related to that? Also wanted to touch base on extended school year. I poked at this with you in November of 2022, that there were changes on the horizon. Those changes did come to pass, and in an interesting way. So I wanted to talk about that. And then, since we had time today, um, and I will not give you a spoiler alert, but there's a particular theme that is emerging as so significant in recent cases both from the Office of Administrative Hearings and from the courts up to and including the Ninth Circuit Court of Appeal, really even the Supreme Court. So I kind of wanted to touch base on what I'm seeing in recent cases and literally talk about those cases, lessons we can learn from them, and in particular, one theme that I'm seeing emerging that I think would be a message I'm hoping you can deliver to all of your folks who are sitting with parents every day, probably right now as we speak, in IEP team meetings and having those critical conversations. So I wanted to talk about some of the themes we're seeing. I don't know if it's too optimistic to say post-pandemic, but at least we have returned to in-person instruction now for some time. And I don't know about you, but still, even in the cases and in our lives and in our work and in our services, we're still seeing those issues. playing out in a number of ways. So I wanted to talk about that. And frankly, anything else, if as time permits that you might, want to be sure that we touch base on or just chat about, we're open. We can keep this open-ended. But for now, I will plow ahead unless you tell me to stop, Jennifer, or anybody with some questions that you might have. Oh, look, I was trying to change the slide myself. How soon I forget that I've already given up. So thank you. I think Jennifer's got this down to a science too. She knows exactly when to anticipate that we're about to shift. So let's talk about the legal framework related to appointing surrogate parents. And one of the things that's pretty interesting about this from my perspective is that there is quite a good amount of federal law surrounding the issue of surrogate parents. And I know, I suspect that this is because from the very beginning, from the foundation of the IDEA and the law in the world as we envision it, places such a key role and prime importance on the involvement of parents in the IEP process. And there has always been concern on the part of the legislature, on the part of Congress, the Department of Education, regarding what happens to students in the IEP process whose parents cannot be or are simply there aren't parents, or they're unavailable, or they are missing in action, or they are incarcerated, or they are incompetent, or whatever the issue is. What happens then to students in the IEP process whose parents are not there to speak for them and to support the IEP process from a parental point of view? So long ago, the federal regulations have included pretty significant provisions related to surrogate parents. So these first couple of slides, and let's start with this one, are directly out of federal regulations, federal law, which, by the way, we will see have been adopted into California law with a little bit more detail. But federal regulations for a very long time have said that in order to protect a child's rights and in order to ensure that there's an advocate at the table who is solely focused on ensuring the parents' rights, a surrogate parent must be identified under certain circumstances. The first is when no parent can be identified. And the thing there that I want to remind you of, because it's easy to forget this, that parents within the meaning of special education law is a more expansive definition than parents under any other provision of the education code. And that's done for a specific purpose. And the law was amended, particularly when it became so common that children were represented by relative caregivers, grandparents with whom the child lives. And the idea sort of emerged that so many children now are being raised by grandparents or by other relatives, but those folks didn't necessarily have the right to come to the IEP process and function as parents. Remember that the Ed Code now includes and was expanded to include a caregiver, in particular a relative, but it doesn't necessarily need to be with whom the child resides. Again, the idea is that the IEP process shouldn't get bogged down in searching for a parent who may never be found, who may be on someone we can't locate or someone we can't reach. So where a child, for example, lives with grandma, that grandparent, without any particular action at all, can come to the table and represent the child's interests. The caveat to that is the grandparent cannot do that if the parent, wherever he or she is, steps in and is assuming rights as a parent in the IEP process. But if that parent is not, then the grandparent can come to the table, consent to the IEP, can be considered the parent for the purpose just of the IEP development process. So just know that there's a pretty expansive, by design, definition in California of who a parent is. But where a parent within the meaning of those definitions can't be identified, and then the district goes on a search for that parent, and a parent cannot be located. Federal law also says that a surrogate may be appointed if a child's a ward of the court or an unaccompanied homeless student. So those are the circumstances generally. If there's no parent that can be identified, or no parent within the meaning of the law, or the actual parent or guardian cannot be located, and there have to be efforts to locate that parent. Secondarily, when that's the case, then under federal law, every district, and sometimes for many districts, that's through their SELPA processes, has to have a method for assigning an individual to act as a surrogate. There has to be a process, A, for determining whether a surrogate is needed, and B, for assigning the surrogate parent. What we know about what a surrogate parent can be on the next slide is that a surrogate can't be an employee of the district, or, by the way, any other agency that's involved with the education of the child, or have a conflict of interest with respect either personally or professionally, something that just feels like this is going to stand in the way of them being able to be objective and committed to the IEP process, and also has to have the knowledge and skills. And that's an interesting dynamic. And and Jennifer can speak to that, but I believe within the Santa Barbara County SELPA, there are particular provisions to ensure that piece of it. And I think it's a critical issue. We want to ensure that those parents who come to the table have a general understanding of what the IEP process is, what their involvement would mean, what consent means, what being a child with special needs means, all of that. And then the skills, really the personal dynamic skills, has had some training and support in becoming a successful surrogate parent. So those are the provisions of federal law. The Ed Code adds just a couple of things to that, making it very clear, and that's on the next slide.
Jan, real quick question, and
Oh, yeah.
I know the answer to this, but I just I wanted you to be able to address it. Sometimes our siblings are very close to the student with the IEP, and we do have a question: could a sibling take the role as the parent in the IEP?
And I saw that, and I was going to wait till the next slide to answer it, only because, but yes, it's possible. If a sibling is an adult, and particularly if the child lives with that sibling, we may have an adult sibling. I would not appoint a surrogate parent who is not an adult. But if there is an adult with whom the child lives, you wouldn't even have to appoint that person as a surrogate, because that is a relative caregiver. If the child doesn't live with that sibling, but the sibling meets all the other requirements, and in particular has knowledge and expertise and skills to do the process, it is certainly possible. The Ed Code says, and makes it clear, because sometimes there's a question about the role of the surrogate parent. So California law kind of filled that in, and it's alluded to in federal law, says the surrogate parent, once identified and once appointed, represents the student in everything, in all matters related to identification, evaluation, placement, and services, provision of FAPE to the student. And that particular phrase is used because that's the same phrase that's used when the law talks about what are the issues as to which a parent may request a due process hearing: identification, evaluation, placement, the provision of FAPE. And it's intended to be entirely encompassing, related to the child's special education needs. And that includes the provision of written consent to services, to assessment, wherever informed parental written consent is required. The surrogate parent is authorized to do that. And to the point also about siblings, and interestingly, and kind of weirdly, but for historic reasons that are not wildly important right now, there is a government code provision as well that adds some flesh to the bones of surrogacy and surrogate parents in the IEP process. And those are on the next slide. That's in government code, just so you're aware of this in your lives, Government Code 7479.5. These, by the way, these are the provisions of law that have housed various provisions related to serving students with IEPs. It's where all of our mental health provisions used to be until 2010, when Governor Schwarzenegger did away with them. It's where we have other provisions regarding CCS services and our collaboration with them, and then just some other provisions related to providing services to students in the IEP process. Government Code says, as a first preference, the LEA should consider a relative caretaker. So that would be not only a relative, but also a caretaker. And bear in mind that the Ed Code has now been amended to say, if it's a relative caretaker, that person is a parent within the meaning of the law, or a foster parent, or a CASA. Those might be folks who would also be appointed, could be appointed by an LEA as a surrogate. It's interesting because I think there's some dicey issues related to foster parents or CASAs. Generally, the courts have weighed in on whether these, either a foster parent or a CASA, should have educational rights. And typically for foster parents, it's an interesting question, because very often I will see foster parents coming to an IEP process, and some teams will presume that the foster parent has educational rights and allow not only participation, but even written consent from the foster parent with respect to special ed services. So bear in mind, I think it's more typical, certainly it is up here in my neck of the woods, that foster parents don't have educational rights. Courts typically, in appointing foster parents, will consider whether they're going to transfer educational rights to the foster parent. But more often, the courts are also balancing the desire to reunite the child with their natural parents, biological parents, and so will retain educational rights or keep them attached to the parent. So you want to be sure you have court documents. My experience with CASAs, I've only ever seen one CASA who actually was appointed because it was an absent parent, who was appointed by the court to be the child's, to have educational rights with respect to the parent. But I would say to all of you, as you are looking to appoint a surrogate parent, that would also mean where there isn't some other court-appointed individual who has educational rights. So you don't want the two of those to conflict. So where you got a child who is a ward of the court or a dependent of the court or involved in the foster care system in some way, you're going to have typically a court order. And typically the court's order will have determined who is the holder of educational rights. And courts want to be the ones typically to make those decisions. They make them based on input from often attorneys or social workers who are assigned to help them do that. So as part of your due diligence in determining whether there is a parent who's been identified, if the court has identified someone with educational decision-making rights, that likely will mean there is no need, probably even ability to appoint a surrogate. Government Code also goes on to say, hey, surrogates, you have to at least meet with the child once in person, face to face. You can't do all of this virtually or simply by attending meetings. You have to actually meet with the child, presumably many more times than once, but at least once. And then surrogates under the law, under the Government Code, have to attend IEP meetings. They have to become familiar with the child's educational records. And they need to be consulting with the educators related to the child's education. Government Code goes on to say, as you choose a surrogate or identify one, if possible, understanding it's not a mandate, but certainly a preference under the law, that should be an individual who can be culturally sensitive as to the child if there are issues of cultural identification. And the surrogate parent needs to be trained in, understand, and ultimately comply with child confidentiality, with the confidentiality that applies to students' education records. So that's kind of the totality of the law. And I know, if I understand it correctly, that within that framework, the SELPA assists in both identifying a cadre of surrogate parents that the districts may have access to, in ensuring that those folks have training in relation to special education law in the process and the IEP process, which is a requirement under federal law. So that's a great thing. You can bear in mind the totality of federal law, state law, and the government code in particular around all of the preferences. Again, the first preference is to a relative caregiver, foster parent, or court-appointed CASA. I still think a foster parent or CASA may or may not be a good choice. And again, it is not a mandate. It's just a, hey, if there's someone like a sibling who seems like a good choice and might be great for this, go ahead. As a first preference, consider that person. But ultimately, the decision about who to appoint rests with the LEA for someone who is competent, is capable, will get to know the child, will participate in the process, and will advocate for the child accordingly. That's kind of just so you have it as a reference, that's, the laws addressing and related to surrogate parents and appointing them. Sometimes I find that the issue is, I don't think the district that I'm working with, perhaps they're moving to appointing a surrogate because they think the parent who is available and possibly involved might have issues related to the parent's competence. That isn't really addressed under surrogate parent. This is truly where parents can't be identified or can't be located. It's not about a determination that the parent is right for the job. We have many parents who present challenges to us or are competent. It really is related to parents who just simply cannot be located, and the child needs an advocate in the process. Jennifer, is there anything you want to add to that, or anything I missed, or any thoughts anybody has before we move on to my just sighing about service tracking?
I think you did mention, Jan, that we do have a surrogate volunteer process.
Mhm.
5 amazingly trained parents of students with disabilities who have volunteered through our Alpha Family Empowerment Center to support this process. And so we are always fine-tuning this process in our SELPA, and just wanted to speak on that, as the inquiry of surrogate is becoming more and more prevalent in our area. So
Okay.
thank you.
Great. And who better than parents who have experienced the process firsthand and truly understand the ins and outs of it. So that's great. All right, service tracking. I know that, and I can't pretend to know what it's like to be in a district or a SELPA where the obligations are coming down from CDE related to service tracking and IEP implementation. Those are not found in the law. That's the challenge that I have, is they are direct communications from CDE to all of you, and they have been changeable. But I wanted to remind us why. And this process literally goes back, what is it now? Close to 30 years that this process has been on the table, ever since there was a class action lawsuit brought against Ravenswood School District by 8 students. And they sued not only Ravenswood, but the California Department of Education, because their argument was that Ravenswood had failed them, but that, more to the point, the California Department of Education had failed them because the California Department of Education, under the IDEA, has the obligation to track and ensure compliance by school districts with state and federal law. The lawsuit was brought, as I recall, by the Stanford Law Clinic, which has then a revolving door of Stanford Law School students with endless energy to continue and to continue to move this litigation forward through the courts, because it continues to be the subject of motions and hearings and orders to this day, just in recent months. there was a consent decree, and the consent decree meant in 1999 that the case is resolved if the California Department of Education does these things, and if they do, then we will end as the courts our oversight of the California Department of Education, and that has not happened. In 2014, out of frustration that nothing was happening with respect to the consent decree, because the courts were very frustrated with how California Department of Education was or was not moving forward to meet its obligations under the consent decree, CDE was ordered to reform its statewide monitoring system. But again, that order was 10 years ago. In recent years, and just in the past two in particular, this has really become the subject of very focused orders from the court. And so what we saw a couple of years ago is the acceptance of, and that was after years and years of wrangling and going back and forth and work in and out of the courts. What ultimately was agreed upon essentially was a 4-tiered implementation system, a 4-track system, one building on the other. We are now, I think, in track 3B. But that, from the perspective of the courts, is where we are now, and it's where the rubber is hitting the road, where CDE must demonstrate through a tracking system approved not as a function of it being a law, but approved by the court to track whether IEP services are being implemented in the state. And so, as we kind of talked about a little bit before, that is where all of this is coming from. That's why CDE has first it implemented kind of a trial period, now continuing to look at and refining and revisiting and rediscussing and redirecting LEAs to comply with tracking systems. And this is all to ensure that it meets the demands from both the court system in California, as well as the feds who are responsible for states' implementation of their obligations. And that's really where it's coming from. I know that there are frustrations with it, that some of it, by the time it gets to the LEA level or the SELPA level, it just doesn't entirely make sense. And I see examples of where our reporting isn't going to really get to the information being reported that's accurate in terms of implementing, accurate in terms of whether we as a district are meeting our obligations to implement IEPs, but it continues to be something of a moving target, and it is always subject to whatever changes arise in the courts. But just understand that this is part of a nearly 30-year process of implementing, well, it's certainly a process that began in 1999, implementing a consent decree from the courts. And it's hard to say much more than that, other than continue to expect the unexpected and to expect that there will continue to be changes and modifications, and continue to provide your feedback, possibly directly, possibly through this, more likely through the SELPA, regarding what does and does not make sense about the service tracking process. But that's where it is. Any other thoughts about that? Okay. I didn't actually have slides in particular to talk about related to adult students and consent, but it is kind of a frequent topic of discussion, because what the law says is what we all know, that with respect to students who are reaching the age of majority, which is 18, we are obligated in serving those students to advise students and their parents by the age of 17 that when they turn 18, the rights will transfer as a matter of law to the adult student. Educational rights related to special education. Frankly, there isn't really a parallel in general ed law, so it's never been entirely clear whether rights transfer under general education law to adult students. We tend to think generally they do, but there isn't such clarity. With respect to students with special needs, there is clarity, and that's where a particular purpose that you and I can well imagine what that is, which is parents, we're giving you and your nearly adult child notice of this, and especially parents, because as your child moves into adulthood, if there are concerns about whether your student has the competence to make educational decisions, has competence kind of generally in life to manage their own affairs, to manage their own finances, to make their own decisions, including educational decisions. This gives you a year to think about and to act on whether you need to ensure that your child is protected by a conservatorship, whether the parents become conservators or whether somebody else becomes conservators. But it's sort of one of many, you know, wake-up calls to parents that these things now need to be addressed. You need to be thinking about this. Time is running out. Time is short. Undoubtedly, you've been thinking about this your whole lives, but now's the time you're going to need to take some action if you intend to be to be if you intend to take over as conservators. What we find is that we come to the student's 18th birthday for many students, and I'm talking in particular about students that we're concerned about in terms of their ability to really even engage meaningfully in the IEP process, much less make informed, thoughtful decisions. They may lack the intellectual capacity to do that. They may lack capacity in a variety of ways to do that. But we may believe the student and doesn't have the capacity, but there we are. The student is 18, the student is not conserved, rights have transferred. So how then do we manage the IEP process with a parent who no longer has educational rights? Truly none. As a matter of law, they shifted on the child's 18th birthday when that student became suddenly an adult. But we have a student who isn't someone who can manage their own IEP process. And I think that, Jennifer, is some of the challenges that you're seeing arising related to students. And I will say this, that I see that there are a number of opportunities during the course of that year to then have ongoing conversations with parents. I think we come to the meeting before a student turns 17, we make note of it, we comment about it, but maybe we don't engage with parents along the way about, what are your thoughts? Are you seeking conservatorship? Often we do. Maybe we haven't. Maybe there's a presumption. Of course, they're going to seek a conservatorship. This is a significantly disabled young adult, but it doesn't happen. Bear in mind, maybe in the course and scope of those conversations, because we can't force parents to do that, and there may be all kinds of reasons, financial, time, otherwise, lots of barriers along the way to parents actually getting into court, doing what's necessary, because it is a court process and it is significant. There are much easier avenues that you have. The Office of Administrative Hearings has always said, first of all, in relation to that question about what do we do with the student that we don't think is competent to make educational decisions, beginning with the Special Ed Hearing Office before 2005 and since, hearing officers have always said, you don't get to make that decision, or your worries about that don't have legal weight. The student, if he's not conserved, is presumed competent. So A, that's number one. You might think you have a legal obligation to be working on getting consent from someone whom you believe to be competent to do that, but there isn't any legal requirement to do so. And in fact, the law says if a court has not found this young adult to be incompetent, neither can you. So you must presume competence. But that isn't very often, it isn't in the student's best interest to do that. So secondarily, you might engage in a conversation with parents to say, your student can transfer educational rights back to you very simply. Because I think sometimes parents will think, well, even if I'm going to do that, do I have to go get something notarized or something in a court, or do I have to become a guardian? What do I have to do? And the reality is, again, from the cases, is all there has to be is a piece of paper saying, I hereby transfer my educational rights and decision-making to my parent. And maybe it's signed by an X or with whatever affirmation from the student, but that is sufficient. And setting aside worries about whether the student is conserved or not, or what that might mean long term, in terms of making educational decisions in the IEP process, you can absolutely inform parents that this can be done expeditiously and quickly. And again, you might say, but I don't even think the student is competent to understand they're transferring their educational rights. Again, you are both protected and kind of governed by the notion that the law presumes competence. So in the absence of anything different than that, if a student affirms the transfer of educational rights, then those rights transfer to the parent until the student says, I want them back, if that day ever comes. So it can be done pretty easily and expeditiously. If not, if the student hasn't transferred the rights, or there is not, the parent maybe the student doesn't want to transfer their educational rights, whatever, then we just need to continue to engage with students in the IEP process, explain the process, and you are all the best at doing that as well as you possibly can. And you need to work with the student to get their consent to the IEP, absent conservatorship or some kind of piece of paper that transfers educational rights to the parent or to someone else. It doesn't have to be to the parent. It could be, to any other adult. The student could transfer educational rights. It's kind of the framework and what the conversations I typically have with districts around this, but maybe you have other thoughts or other permutations or other issues that have arisen for you. Just feel free to jump in.
Right.
I find it is a relentless challenge, though, because it's really hard. You special educators always want to do the very best thing for children, and it's awesome. And that's why I love what I do. And sometimes we're faced with decisions we can't change that aren't necessarily the best in terms of getting the best decision making for the student, but at least understanding the framework in which you live, and that rights can be transferred pretty simply if the child will agree.
I think we have Jana comment. Did you want to comment?
Yeah, what I've run into is there's been no discussion whatsoever about this for example, a student who is intellectually disabled and nonverbal.
Mm-hmm.
I mean, this student can't even communicate they need to go to the bathroom,
Yeah.
let alone consent. And the parents are completely have no idea. I mean, like I did some assessments for a transition program where they're post 18. And the parents had no idea. Regional Center had no conversation. It doesn't sound like they really understood or had conversations with past teams. And now the child is 21, and they've just been signing IEPs all this time.
Mm.
And that made me, who loves their legal trainings, really super concerned. So I feel like maybe, Jennifer, we need to have like a SELPA-wide training for our ESN classroom teachers about how to handle this particular situation. Because, we have a lot of kids who really are not competent or to understand, that have not done this process. And it would be nice to know that it was as simple, like even I didn't know it was as simple as just having them sign over, that consent. And it would be nice to have a training on that, and then how to document that. Where do we upload that into Cyrus? Do we save that in their special ed records? How can we do that in a legal manner that's appropriate?
And my thought about that, thanks for that, Elizabeth. My thought would be too that training needs to be, that conversation before the student turns 17 probably needs to be more robust than it is.
Right.
Rather than just checking the box on the transition plan. Because the intent is it's notice to the student, it's notice to the parents, but that's the opportunity at the IEP before the student turns 17. We should routinely be opening up that conversation and giving parents resources if they're thinking, well, maybe I should explore conservatorship, and gathering resources for parents about where they might go, what conversations they might have, what resources are available to them to talk about conservatorship and some of the other issues they need to be facing.
I will
Uh,
share. Thank you for the comment too, Liz. I will share that our wonderful Alpha Family Empowerment Center will be having either they have had one or they will be having one. I have to check. A parent training in Spanish and English on the age of majority and conservatorship. So I think that is coming in the next month or two. Yeah.
I was just going to add that I've actually had Tri-Counties call me recently also to get feedback on a student as they were making some of these decisions. So I don't know if that's happened to others, but that did happen here at DP.
Okay.
And I think Liz's comment is well taken too. I think there are teams where they just keep inviting the parent and the parent keeps signing and nobody thinks about it because they're thinking, the student isn't competent. And we just have to be more careful than that.
Yeah, I really think it's a training piece that needs to occur, because I consistently see that not being addressed, across the board. So I feel like it's something that teachers need to be informed of, because I don't think teachers are doing it because they're, lazy or bad. It's just they don't know how really important it is. And I know that our ESN classroom population is the most serious, around this situation.
Well, I made a note for next year or sooner to get that together. So thank you for that, Liz.
And it's interesting too, where parents, and sometimes there's a conservator who isn't the parents, but just to throw it out there that at the age of majority, the responsible district may shift, because at that moment in time, I mean, it probably won't, but from that point on, the last district that was responsible for the student attaches unless the parents relocate or there's a conservator appointed who doesn't live within the district's boundaries. Then it's going to shift to the district where the conservator is. So you also want to be sure that everybody is aware of the potential shifting sands on residency. You are all probably, I don't know if any of you would remember that Santa Barbara is responsible for that law, but it goes way, way back to a time when Devereaux was in Santa Barbara, and there was lots of concerns about who was going to be responsible. And they were ending up being, the responsibility of, I think, probably Santa Barbara City Schools, or, in that arena. And so it was Santa Barbara that, maybe the SELPA, that promoted that legislation some decades ago to just shift responsibility when students turn 18. So there you go.
Thank you.
All right. And I just want to close the loop on our conversation about extended school year. And if you've not been thinking about the fact that the law changed around extended school year, then this conversation is going to be alarming. So I just want to warn you of that. You might, and I almost feel like asking for a show of hands about those who know that the regulation in California changed last spring around extended school year. I'm sure that you do know, but just to kind of close the loop, we were talking in November of 2022, I had noted that there was a proposed regulation. There was a proposal by the California Department of Education to change the law by amending the regulation in California related to extended school year. You are all probably aware, I mean, the difference between statutes and regulations and that becomes important in this case is that the California, and it's sort of a schoolhouse rock issue, which branch of the government is responsible for what? But the California legislature is the one that enacts the Ed Code. But the California Department of Education is the branch of government that enacts the regulations to implement the statutes. And can't supersede what is in California law or federal law with respect to special education. California has long had a regulation, you will recall, pretty extensive about extended school year. It's the one that talks about regression, students who will experience significant regression with limited recoupment. That is, by the way, the standard in every state in the country, one way or the other. So that is absolutely uniform. But California law has always said, and it's been litigated and it's been upheld, that if a student accesses typical peers during the regular school year and the district doesn't run a typical summer school, the district need not provide inclusive opportunities in ESY. Part of the reason for that is that it is a practical impossibility. Another reason is that ESY serves sort of a separate purpose. It's not really to advance students in relation to their goals, but the significant purpose of it is to kind of as a maintenance program for students that we anticipate will experience significant regression and be more challenged in recouping those skills once the new school year begins. So it's a different animal than just an extension of the regular school year and ongoing provision of FAPE. All of that got challenged with the MC versus LA Unified and California Department of Education case. It was a case that didn't necessarily have to go to hearing, but I have no doubt LA Unified had not anticipated that this was going to go where it went. It's a student with Down syndrome in LA Unified, and this is a student who was a fully included student, receiving, significant number of supports, but in the general ed class throughout the regular school year. The district came to a discussion at the annual IEP process about extended school year. And the district had two options, and they were both self-contained classrooms, which is typical. One being what we would consider to be kind of a mild moderate. They called it the core curriculum SDC, and the other more intensive mod severe. Given the intensity of the students' needs and their desire to provide an intensive ESY to ensure, that the student wouldn't regress over the summer, they offered and felt the student required the intensive alternative curriculum. The only dispute at that time was that parent said, SDC is fine, but I want the more mild class because I want my student to be accessing less disabled students given his full inclusion program throughout the regular school year from which he benefits clearly. And the district said, no, we really do believe he requires the intensive program. Parent filed for a hearing. The district prevailed in that hearing. The administrative law judge, this is with the Office of Administrative Hearings, found two things. And one was that given the intensity of the student's needs, despite the fact that he was in a general ed inclusive program during the regular year, it was with substantial supports. In the summer, with the intensity of his needs, the ALJ determined that the more intensive SDC was the appropriate placement. And the parent said, well, and in the context of the hearing, well, what about inclusion opportunities? He's a student who clearly benefits from access to typically developing peers. And the administrative law judge said that California law specifically says districts don't have to provide inclusive programming during the ESY unless they run a typical summer school. This went up to the court, and the court absolutely overturned the administrative law judge. And essentially, by then, just so you know, the California Department of Education, because this case was decided early this fall, the California Department of Education wanted to get itself out of this litigation. And so in January of 2023, 2 months after we talked about this, they actually repealed that statute to the extent that it talked about that requirement that districts don't have to provide inclusive programming. They just pulled that. That was subsection G of 3043. They deleted it, amended the statute, and felt that they were out of it. Well, the court said, well, not so fast. I'm going to examine this question anyway, and found that the regulation was always illegal, that it superseded the IDEA's mandate that you are looking to provide the least restrictive environment for every student during both the regular school year and extended school year. And so it made the comment that it was never an appropriate regulation. The district erred in not considering an inclusive program for the extended school year, upending decades of litigation in California, where judges have been happy to rely on the regulation to say the district did not have to provide inclusive programming over extended school year. The court then also went further and said, it seems to us, and we can all think about the extent to which this is true in our own conversations. It seems to us that you came to the IEP talking about extended school year and said, oh, so here's the district's program. It runs 20 days, inclusive of holidays. There are now 2, so that's the ESY program. That's what it is, a 20-day program. This 20 days having come from California regulations that talk about the necessity for 20 days and 4 hours a day in order to drive funding for programs, for extended school year programs. And it has become very common to have conversations that just presume that that's our ESY offer. That's what we do. So they lost on both of those issues. So it's important as you come in, as you are having conversations now, as you are thinking long-term about designing your extended school year programs, and maybe that's kind of on the next slide, we need to be thinking about how creatively are we going to offer opportunities for students to access typical peers where there are students who require them, who substantially benefit from them. But the decision says the LRE requirement applies to ESY just as it does. And so the conversation about inclusion and opportunities with typical peers now doesn't change when we're talking about extended school year. And bear in mind that the courts are now sensitive to this idea, and it's a conversation we need to be having with our teams, that what we do in our extended school year programming to address significant regression with thinking about the possibility of limited recoupment needs to be individualized. We may end up, after a conversation about a student's needs, determining that this program that exists that we've designed is appropriate and will meet that child's needs. But we may think the student just requires 2 weeks. We may think the student requires 6 weeks. We may think the student just requires access to counseling or a certain level of language services. Whatever that decision is, it has to continue to be a child-centered, robust, individual decision, which may land us in our 20-year program in a self-contained classroom, but it may not. And again, we may have to think about opportunities either to, I think, we are in the waning days of offering extended learning opportunities, but we may need ultimately to be looking at other programs, other agencies, other opportunities where we can collaborate to provide access to typical peers for students for whom that is necessary or meaningful. Just a reminder, the world of ESY has changed, and there is going to be a lot of scrutiny on that. Surprisingly, I've not yet seen that arise in a new wave of litigation, but I do anticipate it. And it's kind of a good segue into the cases I'm going to talk about, because and I sort of note this on the next slide, that what I'm seeing in the cases that are arising is this predominant theme about significance of conversations we are having that truly engage parents in a meaningful, transparent way in the IEP process. So before I go into launching into some of the cases that are examples of that, both, where districts have done a great job or where maybe they have fallen short, from the perspective of the judges and the courts, I just want to pause for a moment if there are any other thoughts about extended school year, if you were well aware of this, if you're all over it. I don't know the extent to which you move forward, you likely have, but just kind of wanted to let you know, because this case hadn't come out until the fall. And so when we talked about the potential shift, this case hadn't been decided. So now there it is, cemented in a district court case. And we now know what the court's perspective is on all of this. Are we good? Are you still there?
I think
You
everyone
hanging with me?
quiet and absorbing. Quiet and absorbing.
This is kind of overwhelming to think about. I'm so glad that I'm not an administrator because I don't know how you would possibly administrate a program that meets those legal guidelines with the funding available.
Yeah, I think it has certainly, it's not been the state of the law in California forever. It's not been the way we've thought about designing extended school year programs. So it is a sea change. And districts are thinking about all kinds of creative ways of just trying to address having opportunities available for students in collaboration, maybe with private schools or programs that exist on their campuses, different facilities too, just in creative ways that doesn't have to mirror how it's done during the regular school year. But if access to typical peers is important for language development, behavior modeling, continuing to maintain skills, maybe for social skills or, generalization of skills, we will have to be thinking about where can we create, MOUs or other opportunities to allow that to happen. All right.
Okay.
However, again, I thought, well, that's a perfect segue into this theme I'm seeing emerging, where districts both have survived in due process cases because of the clarity and transparency and professionalism of their conversations with parents, or where they are kind of stepping back from that, or not being clear, or not being transparent, or simply not having conversations that we are required to have in the IEP process. Those are coming to the fore to tank districts' ability to defend their actions in a due process hearing. And I know we've talked about NJUF before. I hardly let a day go by where I don't want to talk about NJUF. But as you all think about discussions with your teams, NJUF in 2017, from my perspective, reignited the conversation about conversations. And it did it in a way that was intended to be very, and was, and has been very favorable for districts. So just a reminder, because as I get older and you all get younger, I'm reminded that sometimes it's good to just walk a little bit down memory lane. So kind of on the next slide, we're reminded that, the IDEA was put into place in 1975. No definition in the IDEA of what it really means to provide a free, appropriate public education. Congress left it to the courts. So we have the Rowley decision in the early 80s. And the Rowley decision, which school districts across the country have been subject to what the Rowley court said, because this was the United States Supreme Court, governs every state, about what it means to provide a free, appropriate public education. And we all know, and this is why legal discussions become critically important, that the Rowley court said you can deny FAPE in two ways. One, purely procedural. The IDEA, state law, state regulations include a myriad of procedural requirements. Under federal law, the feds counted them up and said there are more than 800. There are a lot. And what the Rowley Court said, what the Supreme Court said in the early 80s, was those are as important as doing the right thing in your classrooms, providing the right program. Procedural compliance ensures that parents have the right to be meaningful participants in this process. And we believe, as we sort of started our day with the discussion of, that parents are critical to developing IEPs because they are going to be, said the Supreme Court, the strongest advocates for their children, and they know their children well. So if their true involvement in the process, which is far greater than parents have any right to be involved in general ed, is going to be significant. And if your failure to meet any of these procedural requirements means the child didn't have access to FAPE, or more significantly, the parent was denied the right to participate in the process, that's a denial of FAPE, regardless of how well you've served the child. And that's the legal reality you all live with, is that almost all cases are about process because they're brought by lawyers in front of lawyers. And do they want to talk about what's going on in classrooms, or do they want to talk about process? They're almost all about process. At the same time, the Rowley Court said, but you also have to do the right thing in your classrooms. Design appropriate programs calculated to provide some educational benefit. And we've talked in the past about that notion of some educational benefit written to say the most important thing is least restrictive environment, access to typical peers. That's the problem we're solving. Children are being excluded from classrooms, from typical classrooms and typical peers because of their disabilities. Let's solve that problem and have that child in that classroom, even if it means they're just getting some educational benefit. That's where they belong. But over time, that wasn't sitting so well because it sounded like we had a low standard for children with special needs, just some educational benefit. It was about access, but that wasn't feeling very good in light of the accountability movement. And so only one time since, in 2017, the Supreme Court revisited what it substantively means to provide a free, appropriate public education. And that's the case when we talk in IEP team meetings about what we're designing this program to confer. That's the case we should be citing. And that's the next case, which is Andrew F. So Andrew F. started in 2016. This arose in Denver, Colorado, where the standard for determining whether the child was making some educational benefit was very low. It was just, if you could sort of glean some progress on some goal, that was enough. Got all the way up to the Supreme Court with, lots of arguments and briefing about it's time to change this standard. And the Supreme Court said, we're not really going to change the standard, but we do want to expand it to include all of our students, because the Rowley decision was about Amy Rowley, child who was deaf, very bright, progressing from grade to grade, consistent with her peers, above her peers for the most part, but that's not either all or even typical of the students we're serving in special ed. And so the Supreme Court said this. In 2017, it said the level of educational benefit, the standard is different. That's on the next slide. The Supreme Court said, rather than developing IEPs to enable a child to make some educational benefit, we need to be developing IEPs reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances, and we have to be writing appropriately ambitious goals. That kind of changed the nature of what we're thinking about doing. Reasonably calculated to enable that child to make appropriate progress while being appropriately ambitious. And a couple of things happened since Andrew F. One, if you read the last pages of Andrew F., and you should, because it's only like a 10-page decision, the last pages said sort of what I alluded to. Courts, why are we involved in this? We, as lawyers and judges, don't know about education. We should be deferring to educational experts, and where they make clear, supported decisions, then we ought to just step aside and stop second guessing whether they've offered FAPE. That's what the Supreme Court said, and it made a difference. We've seen that. We've also seen, as we talked about when we talked about kind of the dynamics around inclusion, that this led to more programming, probably that's been more intensive as time has gone on, because we want to provide a child with appropriately ambitious progress. But the real upshot was this. The Supreme Court said, if you engage with parents, don't just hand them your offer, have meaningful conversations, explain the rationale, explain how you reach the decisions that you make, and document those decisions and document your rationale. The more you do that, the more we will defer. And that is definitely true. But it put an emphasis on districts. You should prevail if that's your decision, but only if you had a conversation, and only if you were clear, and only if you got feedback from parents and heard their thoughts about it, and then documented your rationale. And so a lot of the decisions that we've seen since then have focused, and I think it's been a subtle shift, on whether, as we ask courts in due process to support decision-making made by districts, the question will become, how well did you engage with parents in that process? Did you have those discussions? And, I think of them as happening in your training of your staff at so many times where I think we miss opportunities, even at eligibility discussions, where who intuitively would ever know that eligibility and disability are not the same thing? And we have parents coming with their, Kaiser prescription pads wondering why we're even discussing eligibility. Isn't it true? The experts have spoken. So a conversation about, let's explain the difference, that eligibility and disability are not the same thing. Disability is one half of the discussion. Eligibility also includes whether a child needs special ed, those conversations. And I will also tell you, I think we've talked about this, that conversations when we come to placement and services, truly explaining the continuum, what it means, what options are available for the team to consider, and then initiating and eliciting parent input about that. What are your hopes? What are you thinking? Why are you thinking that? Well, let's talk through where our goals lead us, what our rationale is. We're hearing what you said. It kind of helps us shift our thinking a bit. And here's our proposal. But conversations matter. So I just want to talk about a few cases, although I've arranged them alphabetically. So this one happened to come up first because it's kind of the antithesis of this. Because sometimes the conversations can be super challenging for all of you because of the nature of the work that you do. You work, I'll say it in the sanctity of this discussion, for the government. And that means that those who come to you for conversations are also protected in terms of free speech rights and the ability to seek redress from the government and air their grievances. There are constitutional protections related to that management at Safeway doesn't have to worry about. So there's another level of that. And sometimes for some parents that may empower them to engage in communications that might range from angry or disrespectful all the way down to threatening communications. And what are the possibilities there? It's just interesting that this case went up to the Ninth Circuit Court of Appeals. Remember, we've got administrative decisions, court decisions, the Ninth Circuit Court of Appeals, which is the last stop before trying to see if the Supreme Court will take your case. But the Ninth Circuit Court of Appeals is important because where the Ninth Circuit Court of Appeals issues a ruling, it governs all the Western states all the way down to what IEP teams can do. And the Ninth Circuit is traditionally very parent-friendly. Will typically rule in parents' favor in most cases, though we've seen some recent different examples. This is a 504 case, but it could have been an IEP case. Dad, who is a vigorous advocate for his young daughter with anxiety, came to a 504 meeting, believing and expecting that the team was going to develop a 504 plan for her. The team, based on its 504 assessment, did not believe she required a 504 plan or 504 services and accommodations to address her anxiety. So they left the meeting, parted company, and the dad became angrier and angrier, and began a series of email communications, coming at night, coming during the day, getting lengthier and lengthier, angrier and angrier with, the press and state legislature, carbon copied into all of it, the governing board. And they truly did become increasingly aggressive. Staff felt kind of bullied by Dad's communications in some ways, particularly in relation to an administrator, whom he said was just an incompetent, an idiot, the administrator who had been at this meeting. And so the district said, we really do need to put the kibosh on this. So they said, look, Dad, because of the nature of your aggressive communications, staff feel threatened. We can't allow this to continue, and we can't be responding to your daily emails. We're going to impose a communication plan. You can communicate with us as much as you like, but we're going to gather them up and have twice monthly meetings with you, an administrator and one other, where we will address the concerns that you've raised in the past 2 weeks. Well, it was kind of okay, worked for a while, and then Dad said, wait, I don't like this. So got angrier and was insisting on other staff responding to his concerns. And the district said, okay, we're down to once a month. Now that's when we're going to meet. And the parent filed ultimately in the courts to say, look, districts can't do it. I have First Amendment rights to free speech, to the government. I can express my concerns, and this communication plan is putting the kibosh on my right to free speech. Went all the way up to the Ninth Circuit Court of Appeals, which supported the district. And I think it's interesting as we think about sometimes how we need to manage communications outside of the IEP process, because I have had many conversations before this case came up in 2020 where I wasn't sure what would happen in the courts. What kind of limitations can we impose? And interestingly, the Ninth Circuit, a very parent-friendly circuit, was pretty horrified by the kinds of communications it saw were going to district staff from this very, very, very angry parent, and said, if you create a communication protocol, a plan to manage what have been very challenging discussions, that doesn't impose, Dad, on your free speech rights, because it isn't telling you can't communicate. The district is only managing how it's going to respond. And free speech doesn't mean you have a right to a response to every communication or a right to a response at all. So the district's managing its responses does not infringe on your free speech rights. So I just think it's an interesting case that, now that I've kind of brought it to your attention, may come up for you in some context where, and particularly though those conversations that occur outside of the IEP process, whether or not those are parents of children with special needs, because you would want to treat them the same way, but there may come a time where you need to try to manage those communications so that staff feels safe, and so that they are safe and not threatened and can manage the work that they're doing for children while managing these communications. And you can create plans to manage those. That's really what this case stands for. Let's talk about kind of another category of cases, because the issues around parent consent and discussion related to that has definitely evolved with the Office of Administrative Hearings over time. And the Marietta Valley case, this is a OAH case from 2022. If you want to go on to the next slide. This is a case that arose in 2022. Excuse me, it started in 2020. So it's a 2020 case. There was this pandemic that occurred in 2020, and it did impact significantly a lot of issues related to assessments. District sent out the triennial reassessment plan related to a student with Down syndrome. Parents said, oh, are we really going to go down this road? And the district said, oh, you're right. This is going to be way too challenging. So they all agreed that they would kind of do an informal assessment process to revisit the students' eligibility and present levels, and everybody was happy. The following year, the student came back to in-person learning, and as has been true of many of our students, had significant behavior issues that had not been seen before. So the district resent the original assessment plan to the parent to administer comprehensive assessments because said all kinds of new issues are emerging. He's back. We really do need to assess. But they didn't tell the parent that's why they were sending it. They just sent it. Parents said, no, we're not going to agree to those assessments. District filed for hearing. And districts can do that. Very often districts do that, almost universally, because it's in the student's best interest to move forward with an assessment process, especially in light of Andrew F., which says we have to build IEPs that are appropriately ambitious and well calculated based on who we know this child to be, and how we know that is through assessment. And here, no doubt there were new issues, so they offered the assessment plan again. Parent declined, they filed for hearing. Went up to hearing, and the judge rejected their bid to conduct the reassessments. Why? He said, this plan is great, perfectly well designed, meets all criteria, and you're right, district. There are good reasons that you should now revisit the assessment process because things have changed pretty dramatically for this young man, but you had no conversation with parents about it. You never communicated with them why you wanted to send the plan. Parents came to hearing and said, we had no idea, but we just didn't agree. And without that conversation, the district could not move forward with assessment. And as I note on the next slide, this follows a whole series of cases from the Office of Administrative Hearings that have changed the nature of getting consent to assess. In the old days, if we had a child find concern, we would send an assessment plan, and our child find obligation ended the day we sent that plan. Things changed. And over time, and in light of Andrew F., the administrative law judges are saying there has to be more to it than that. This is the beginning of the conversations you're having with parents, especially in initial assessment. So if you want us to order that you can assess without parent consent, you have to do three things. Send the assessment plan with procedural safeguards. That's number one. But you also need to make efforts to communicate with the parents. And then we had a case a couple of years ago where a school site did that. Sent the assessment plan, put it in, it was a 16-year-old student, put it in his backpack, called the dad, emailed the dad, left messages for the parent, and then they filed. And still they didn't prevail. Why? Because she couldn't document that she had done that. So that's the third thing you have to do. But it's just a reiteration. It's just one more iteration of the importance in the cases now about, did you engage with the parents? Did they understand what you intended to do and why? And you can't come and get us, the judges, to reach a decision without proving that you had a good, transparent, thoughtful conversation with the parents, or at least made every effort to do so and documented those efforts. So bear that in mind, because now it's kind of firmly entrenched in the last 2 years in decisions at OAH. You send the plan, you have conversations with the parents about the plan, you reasonably attempt to get them to consent, and you document all of your efforts if you're thinking that it might be a case where you're going to need to file for the right to assess without parent consent. So issues around that came up in Wainimi too, and Wainimi's kind of interesting. This case just came out. It's like 2 months old. Also about assessing a 13-year-old student, this being a student with an other health impairment. The circumstances were different though. This is a 13-year-old living with grandma, had been eligible up till 2019, then was enrolled in a Christian academy for a period of time, then in a charter school for a period of time, and then in about March of 2022, re-enrolled in Wainimi. Within a few months, they had a letter from a nurse practitioner, another letter from a psychiatrist saying we have psychiatric concerns, there are mental health issues. We even think this might be a student with a mild intellectual disability. So the district offered to assess. And the district did know that there had been previous assessments and previous eligibility and issues related to both attention deficits, PTSD. So yes, they wanted to assess. The grandmother did sign the assessment plan. And then the district started reaching out to do the assessment, and the grandparent simply refused pretty much to make the student available. By the way, he hadn't been assessed since he was 7 years old, so there was definitely a real need to get good current data. So without doubt, there was a need for assessment. But then the grandparent started saying, and by the way, the district looked into the history and saw that the charter school had also made many attempts to assess, but the grandparent, with the help of a very strident advocate, was going to have none of it and would not agree. So they had difficult interactions. One of the things that I think was, and the grandparent was saying, I can't bring him to there. He has PTSD from being on your school grounds. You're going to need to do it here. Set up appointments. The student wouldn't show up, set up other appointments. So there were all kinds of efforts before the district filed. And one of the things I noticed in this case, and it mattered to this judge, is the judge said the parent and the advocate were very, very challenging to deal with. And the district was chasing the student everywhere to try to get the assessment in. And ultimately they filed because they felt they ran out of options. But the advantage was, and it's kind of a quote from the case, the judge said they had professional and respectful communications with both the grandparent and the advocate at every turn. So took the high road, maintained very respectful communications. And I know that all of you do that, but it's another thing that will make a difference. And in this world where, God help us, we do so much communication and email that ends up in due process hearings, lots of communications, every one of them can end up in a hearing and set a tone for the judge about the extent to which we were not only diligent, but respectful and collaborative, even where the parent, here the grandparent, wasn't. So they had filed for due process hearing, which is kind of interesting because a judge can't order parents to do anything, or at least there's no implication necessarily of that. Parents can't owe us compensatory, and they can't require provision of services. But what the district asked the judge to order was to order that consent, and then failure to make the child available was no consent at all. That the grandparent needed to be collaborative, and if she didn't, then this child was ineligible as a matter of law, and the district had met its child find obligations. And the judge did agree, said that the consent here was illusionary, that it really was not genuine consent. Kind of relied on this Ninth Circuit case with which I am very familiar, because this was a case that my partner did out of our Oakland office. And it seems like a small thing. Went all the way to the Ninth Circuit on the issue of whether the parent had the right to be present during assessments. It sounds like a small issue. It was part of a much, much, much bigger, longer issue about the parent controlling kind of every aspect of the assessment process. But forever, and particularly reiterated in Andrew F., is the idea that districts have the right and obligation to assess as they see fit, without condition, without interference along the way, and that where parents aren't allowing the child to be available for assessment, that's effectively withdrawing their consent. And so it just underscored both that where districts are maintaining their professional demeanor, that is going to make a difference for an administrative law judge. They communicated, they attempted, they tried different things. They were very, very communicative, but ultimately unable to reach agreement with the parent. So that's another kind of iteration of how the consent cases are playing out. Let's go on. I think I have one more here. And that's the San Jose Unified case. I can probably sort of summarize quickly what this case was about. Again, this, by the way, was also a case in hearing. Judges, even though they are objective and deciding cases on the law, they will align with districts or parents depending on who they feel kind of more aligned with based on a whole variety of things. I say that only because I think the judge in this case very much disapproved of the district coming to hearing with an attorney and kind of browbeating the parent from the judge's perspective. And this was a lovely parent. What happened was this. District sent an assessment plan to the parent for the triennial reassessment of the student. Parent, by history, her first language was Spanish. There had been documentation along the way that that was the case. However, the district had been communicating with the parent in email in English for a long time. And so it sent the assessment plan in English. The parent signed it. And for some reason, it was important to her, and I'm not second guessing that the district include adaptive functioning in the assessment plan. They had not. She thought the assessment plan included it because the original assessment plan from 3 years earlier, which had been translated into Spanish, did include it. This one, it happened, it didn't. So there was the assessment to which parents consented. She got the documents, and then she reached out to the district to say, you didn't assess in adaptive functioning. And the district said, right, well, the assessment plan didn't include that. So the parent said, well, I want an independent educational evaluation. And the district filed for hearing, which is certainly a possibility to defend its assessment, saying our assessment was comprehensive, it was appropriate. When you file to defend your assessment, it's not just the guts of the assessment report and the assessment process and the qualifications of the assessor that the judge will analyze. The judge will step back to the original assessment plan. And if there was any kind of flaw in the assessment plan and the consent to that, then the assessment report will be found to be defective. And that's what happened, as you can see on the next page in this case. The administrative law judge determined that this was a violation of both the IDE and the California law, because California law requires that assessment plans be sent to parents in their first language. And that's where the district's attorney was kind of speaking to the parent and saying, you understand English, you've been communicating in English. Are you really telling us you didn't understand? And the parent, through a translator, said, I'm embarrassed that I don't speak English. I'm embarrassed that I can't write in English. I use Google Translate to translate my emails, kind of hide the fact that I can't communicate well in English. So I don't read it. I didn't understand the assessment plan. I just assumed that it was the same assessment plan I had signed earlier. So the district did not prevail on that because we have to provide assessment plans in a parent's first language. So again, an important thing to check, and this was about parent communication. The parent could not have provided written informed consent where the plan was not sent to her in the language that she spoke. So you need to be aware of that. All assessment plans need to be provided in the parent's first language. You might have noted or become aware that there was legislation in California that was pending to require translation of many more documents, assessment reports, any documents generated at IEP team meetings. That legislation failed. But bear in mind that there are two things required. The assessment plan must go in the parent's first language, and IEPs must be translated if the parents request it. But there's a third requirement, which is, and the district must take whatever steps are necessary to ensure the parent can access the process. So that might mean having translated documents if they're highly technical and difficult to understand. It might mean sitting down with the parent with a translator and going through them, having translators at IEP meetings. whatever we believe is necessary or that the parent requests to access the process, because otherwise, of course, there's a presumption that the conversations aren't genuine if the parent can't access them. So just bear that particular provision in mind. The next case is about FBAs, and it's kind of related. And I'm so sorry for San Jose Unified because it's another San Jose Unified case. But this raised a question for me I actually hadn't really thought about. And it was a very, very difficult parent with whom the district had had difficult relationships for many years. Parent requested an FBA. This is also a dad. Student's already eligible, and sent many, many pages with, I don't know, something like 20 plus reasons why the student needed an FBA. Went to the director. And the director said, of course, we'll conduct an FBA. Although the view was the student wasn't demonstrating any maladaptive or problematic or interfering behaviors at school, but they said, we'll do the FBA. Got a district behaviorist on board. The behavior specialist reached out to the dad, which, as most communications did, generated email communication to the board, to senators, to the special ed director to say, who is this person? Why is she contacting me? I didn't give her permission. I won't speak with her. And so the director said, look, specialist, just go ahead. I have no doubt it was to protect her from these challenging communications with the parent, but said, go ahead, do your assessment. It's an FBA. It's going to be school focused. Do your functional behavior assessment, and we'll come to the team meeting and discuss it. She sent a draft to the dad. He blew up again, but came to the meeting, said, I don't agree with this FBA at all, requested an IEE. And the district said, you know what, it's a great FBA. It's a great report. We're going to file for due process. So went to hearing, and the administrative law judge said, well, I think there's a flaw here, but I don't think it was significant, so I'm going to uphold the assessment. So this particular case went to court, Northern District of California, and the administrative law judge upheld the administrative law judge's finding that there was a problem. Here was the problem. The court and the administrative law judge said the problem was you failed to get parent input. And I would have been thinking, is that really significant around a functional behavior assessment where it's really based on observational data at school? But there's a provision of federal law, keep in mind, that says that every assessment must include parent input. Again, and a part of our theme about engaging parents in the process, and there is no assessment that we can conduct without input from parents. And think about that as you're reviewing assessment reports or coming to a meeting. We have to make sure that every assessment that we do has a process where parents are interviewed or their input is gathered in one way or another. And that even includes a behavior assessment that wouldn't really relate to behaviors at home. It's more at school. Anyway, the court said, look, I understand that it would have been challenging. I understand the circumstances, but you should have at least tried. And it was probably problematic too, because the director had chosen not to give the behaviorist that lengthy communication from the parent seeking assessment in the first place. Maybe the case would have come out differently, but I think he was actually trying to preserve the integrity of the process, protect the behaviorist, said, just you go see what you see and let us know. In the end, because the parent didn't have an opportunity and the district didn't try hard enough to give him an opportunity to provide input into the process, the administrative law judge's order was held up that the district had to fund an independent FBA, though again, the judge found, and then this judge found, that there really wasn't denial of FAPE. It was a great functional behavior assessment report. And the BCBA who did it said nothing would have changed that if I had all the input that I've heard now. So it wasn't a denial of FAPE, but it was a procedural denial that led to the parents being able to get an FBA funded that was independent. So another kind of permutation on that. Next case is about interim alternative educational settings. And I brought this case to the fore because in my practice and in my experience, since students have returned in 2021 at various times, and since we've seen behaviors from students that are much more challenging than pre-pandemic. Significantly aggressive behavior. Students are impacted. Students are changed by their experience over the course of as long as 2 years in their homes and in lockdown. And we're seeing that playing out with substantial behaviors. And so I, more than in any other year that I can remember, I'm having questions from districts. I just had a lengthy conversation this morning about, can we move to an interim alternative educational setting? And you know that the context here is that federal law, which is where all of this law is housed around special ed discipline, including interim alternative educational setting, tell us that districts unilaterally can remove a student to an appropriate, meaning it will address that behavior as well as provide access to general curriculum and to goals and services, but can move a student for as long as 45 school days. Used to be 45 calendar days, now it's 45 school days, a significantly longer period of time, like 2.5 months, where one of three things has occurred. The student has brought a weapon to school, or the student has engaged in, has committed a drug offense, or the student has committed serious bodily injury, imposed that on a staff member, another student. So serious bodily injury, weapons, or drugs. Here's what happened in Palo Alto a few months ago. This is a case from this year. 9-year-old student, and you know that there are very likely issues with this student because they're on a field trip, and this field trip is to go across the street with the class. But the student has one paraprofessional on one side, one on the other, and they are all walking about 20 to 30 to 40 feet back behind the rest of the class. So they are separated, 2 paraprofessionals supporting the student. It's a student with autism. And the principal suddenly hears a shriek from one of the paraprofessionals, goes back and sees that what has happened, and she's wearing a jean jacket and a shirt underneath that. And somehow the student has bitten through both the jacket and the shirt. And now the paraprofessional had a wound. And I don't know exactly how this can happen because it's described as 3.5 by 2.5 inches. So really gouging out a significant chunk of skin. And the paraprofessional at hearing and at the time described this as pain on a level of 10 out of 10. Was out of work for a while, but still was scarred and experiencing pain at the time of the hearing. So the IEP team, the IEP process determined it's a serious bodily injury, and the district proposed an interim alternative educational setting. Parent challenged that, which you can do. Parents can file for hearing. It's an expedited hearing in cases involving student discipline. And they said there are 3 reasons why this shouldn't stand. First of all, I don't believe that was serious bodily injury. Second, I don't think the interim alternative educational setting is appropriate. And third, you had an IEP team meeting, but you didn't do a manifestation determination review, where you make the determination. The administrative law judge looked at it and said that was clearly serious bodily injury, justifying that 45 school day removal. No question, extreme pain, modified work schedule, 10 out of 10, it was significant. And the setting that the district has offered, a non-public school providing intensive behavior support, is appropriate. However, as we have said the court, in other cases, you need to have a manifestation determination review before you can move forward. And the district said, well, why is that necessary? We are conceding it was a manifestation of the child's disabling condition, and we can impose a 45-day placement regardless of that decision-making. So why is it important to have it? And the administrative law judge said, because federal law says you need to have that conversation. And that was another conversation you didn't have with the parent. You didn't discuss whether this conduct was or was not related to the child's disabling condition. And for failing to do that, you can't move forward with a 45-day interim placement. You won't see that clearly in the law. So bear in mind that this is the second decision, and this one is just a couple of months old, where OAH has said, as the feds have said before, you must have a manifestation determination review, even if you are darn sure it's going to come out that it was a manifestation, before you can move for a 45-day placement. The good news here is the judge really did recognize that this was a significant injury and the staff was still reeling from it. The judge could have said, it's all upended, student returns tomorrow, you lost your shot. What the judge actually said was, have that manifestation determination within a quick period of time, and you guys can just continue to move forward. But it's a good reminder to all of us. And I have a second case on manifestation determinations also, because it is also a very recent case just from this past year, but underscoring the importance of conversations at manifestation determination meetings. And again, I'm just seeing so many conversations now that our MD meetings are focused on students significantly challenging, concerning, potentially aggressive or threatening behavior. It's an 8-year-old student. The student had ADHD, still does undoubtedly, attending a Montessori charter school. Walking in one day, and he's overheard by a classmate behind him saying, you know what I'm going to do? I'm going to bring a gun to school. I'm going to kill everyone, and I'm going to shoot my teacher's head off. This is frightening. The student who overheard it goes to the administration. They suspend the student, considering expulsion. Though expulsion for what students say does, as I said before, it carries constitutional implications. Was this just free speech? Did he have a right to say it? Did he mean it? Was it a true threat? So as they often do, the district engaged with their police partners to say, hey, can you go in the home and see whether there actually are weapons? Was this a possibility? As we do our threat assessment, we really need to know what's in the home. Sent the Vista police in. Often there's nothing. That wasn't the case here. They found dozens of weapons in the home. Lists of students' names, the school's address, drawing of people with weapons. They suspended the students and moved for expulsion. So they had to have a manifestation determination meeting. And as teams now routinely do, though again, it's not in the law, they asked their school psychologist to review the records, pull up the relevant findings, kind of connect whether this behavior connected to the student's disabling condition, ADHD. The parent was going to say it was impulsive. Was it? What were the issues? And so they convened a meeting and they had the school psychologist report, and the parent filed challenging and claiming that the manifestation determination meeting was predetermined. And ultimately, as you can see on the next page, the judge agreed. And why? Student had only been in the charter school for a pretty short period of time, so they didn't really know him. They relied pretty substantially on the school psychologist report, which would have been great, but the school psychologist didn't come to the meeting. And so kind of what happened is there's the report, it's put on the table, the parent asks questions, and everybody's just kind of saying, well, it's in the report. Here you go. It is not a manifestation. We're moving forward. So the parent files saying, hey, the problem here is I didn't have a chance to have a conversation. The parent told the judge, there are all kinds of things I would have told you. We're a military family. We make knives during the week. We sell them at a flea market over the weekend. That's why we have all those knives in the house. And hey, that list of students, I was just developing my witness list for hearing. It wasn't my child's hit list. It was my list. And she had a lot of reasons, which may or may not have carried the day, but she didn't get a chance to talk to the district about them. It was a fait accompli. They didn't have the person there who had written the report, and that became a problem. And they weren't able to move forward in this particular case with a student who may well have been dangerous. So again, conversations matter. And they were not able to just rely on putting a report in front of a parent, especially at a manifestation determination. As we saw in the prior case and this one, both from this year, you have to be willing to, and you're going to have to take a deep breath. These are challenging conversations, but they need to happen in order for a judge to uphold the decisions that we make in manifestation determinations. Kind of this last case, maybe there are actually two, but these cases are just overtly about this topic. This San Diego case, I think, is a classic example. I don't think I have mentioned this case to you before. If I have, I apologize. But to me, when I read this case, I thought, in light of Andrew F., and we can go to the point in Andrew F. where it says districts, we're going to uphold your decisions. You are the experts, but it has to be preceded by a conversation, or that's predetermination. That denies parent participation, and that is a procedural error you won't overcome. And that's going to require us to take a deep breath, to take more time, to offer better explanations to parents about the process. And here's what happened here. And I think some of you, from what I've heard, work with an older population of students. Here's a student who's a student with autism, significant intellectual disability, and very aggressive. District had never been able to manage that. And in fact, the student had been in a non-public school residential program all the way up to his 21st birthday. The problem was the residential treatment program was only licensed to have students up to their 22nd birthday, and that was going to occur in March of 2021. So they were going to release him, and because his age was falling in the spring, his birthday, the district needed to serve him through June, through the end of the fiscal year, right? Just as a function of California law. Well, the parent had been anticipating his return for a long time in San Diego. They bought him a townhouse. They removed everything from it that might have a sharp edge or be dangerous. They padded the walls. They hired staff 24 hours a day. And they said to some district staff members outside of the IEP process, all we're going to want you to do is provide some educational programming for the next 3 months. We're good to go. This is the decision we've made about how we're going to move forward. Well, the district was kind of horrified at the thought of that and the thought of this kind of padded cell in which the student would live. They didn't want to be part of that. So they came to the team meeting, and think about team meetings you've had. They sat in the team meeting and said, we do have a continuum available to us. What we think what we want to propose that we'll provide to your young adult for the remaining 3 months is placement in a therapeutic program, and here's our offer. And the parents said, well, okay, we're surprised though. We've given you already some heads up of what we want you to provide. That's what we'd like to discuss. And the administrator at the meeting said, I'll document that. We might respond to you in writing. But we're not going to talk about that today because this is where we are in the continuum and we've made our offer of faith. Parents filed for hearing saying this was a flawed proposal that couldn't stand because of lack of parent participation, and the administrative law judge agreed. And the judge said, look, district, I understand. Maybe that wasn't going to be workable. Maybe it wasn't even legal and you didn't want to engage in it. But that is never a reason. Parent lack of cooperation, parent belligerence, parent challenges at meetings, parents' desire to move it along, none of that is a reason where you can upend the process and not solicit parent input and not hear their concerns. It led me to think, subsequent to this case, that when we get to placement, placement is our offer. And so it's kind of an awkward shift in the conversation because everything up to that point is collaborative. We gather input, we hear input, we make amends. But once we come to that offer, it has to be our offer of what we believe will provide that student with faith in the least restrictive environment. But that offer needs to be preceded by a genuine discussion about the continuum and soliciting parent input, in my opinion, about what they would like to see in the proposal, because otherwise we end up, and there have been other cases just this past year where the district felt they couldn't get through the process and just said, well, here's the offer. We'll put it in writing and you can respond in writing. It's another temptation, I think. And I think we're being lured into this sometimes by those representing parents who say, well, give us prior written notice, give us notice. Or we say, we're going to write a prior written notice. Writing prior written notice in lieu of conversations at team meetings is going to get us into trouble. I have evolved in my thinking to say, when I get a demand to say, we had the meeting, here's our consent, but here's our exceptions, give us prior written notice, or here's what we want to say. You know what we're going to do? We're going to reconvene the team, and we're going to have these discussions in the team meeting, which is where they belong. And we may follow that up with a written explanation, but we're going to explain it at the team meeting. And we're going to have those conversations, as Andrew F. says, if you have open, transparent, sometimes very difficult conversations with parents at a team meeting. Again, San Diego is just a perfect example, because the judge wasn't saying the district had made an inappropriate placement. It just said it did it without parent participation. And that means that the IEP process, ultimately the offer didn't stand. I do think I might have one more case kind of on this topic. It's an LA Unified case. I just found this interesting and wanted to throw it out. It too is a meeting about an annual process, because sometimes I know that we struggle with, but what about when the conversations go on too long? Is there a point at which we just need to get to the offer of FAPE? And is there also potential liability if we haven't for months? That's how this case played out. And it was the first case I've really seen to overtly assert what was asserted here. So I thought, and it's also a very recent case. District had a meeting and they started the annual review for a student with Down syndrome on time. It was June, February 2019. That's when they met. The parent had requested a number of independent assessments. One was AAC and AT. Actually, it was combined. The assessor did both. But there was also a psychoed outstanding. And the parent said, I really don't want to talk about placement and services till we hear from my independent assessor. So they agreed to postpone for a month, reconvene, and have that discussion. And they did. And then they came to that and they began to talk about placement and services. And the parent said, well, I'm thinking I want a comprehensive high school placement. I'd like to just go see. And the district said, okay, well, we'll reconvene after you've had a chance. Again, bear in mind, I'm not saying that parent observations prior to making an offer are necessary, but the district in this case believed it was the right thing to do, and they gave the parent the benefit of the doubt and had the parent observe some classrooms. Ultimately, the offer of FAPE was made right around Memorial Day, the end of May 2019. Parent filed, and she said it was a denial of FAPE from February 2019 to May 2019 because my last annual review expired, and you didn't have a current offer of FAPE in that period of time. And that's a scary proposition. Imagine if that were the state of the law, that if we don't have a full offer on the table by the time the annual comes and goes, it's an automatic denial of FAPE. But that's what the parent's attorney was asserting in this case. And it went to the administrative law judge, who found in LA Unified's favor, and it went up to the court, and the court just decided this in favor of the district. It said, and it sort of debunked the notion that IEPs expire. It said that was the IEP, and the district was continuing to implement that IEP in good faith. And the district was smart enough to have their staff come to the table and testify in this case to say, oh no, I was continuing to implement, he was continuing to make great progress, all was well. And And the administrative law judge and the court said, you know, remember the Doug C. guidance. This is the Ninth Circuit case in 2013, which said if parents say they want to come to the table and the district is saying, but the annual's due, we're going to have the meeting come hell or high water, you always need to err on the side of parent participation. And as long as parents aren't telling you we won't come, they're just saying we can't come, then you need to continue to try to accommodate the parents' preferences and desire to postpone. Similarly, the court in this case said all the delay, whatever that delay was, it was all in the interest of parent participation. It was because parent wanted the input from the independent assessor. It was because parent wanted a better understanding of what the comprehensive school site had to offer. All of those delays served that interest in parent participation, and because they did, it was perfectly fine. And IEPs don't lapse. They just continued, they continued to implement it, and that is not a procedural error leading to a denial of FAPE. So that was kind of interesting because we were sort of holding our breath that if the courts were to say that we have to have a full IEP on the table by the annual review date, that was going to lead to an early retirement for me and many of you. So that's kind of how we ended up in this particular case. Again, a reminder that in the service, now had the district said, we're going to have this meeting and we're going to have it because the annual is due and we don't care what your concerns are, it would have been a denial of FAPE, I assure you. So, or had they said, we're going to postpone for 3 months because we just can't fit you into our schedule and we can't get our staff, that wouldn't have been good either. But here, it was in the interest of parent participation. Wow, I didn't exactly leave lots of room for robust discussion because that brought us right to the end of our 2-hour period. But I see such a strong message in the cases about taking a breath, slowing down, explaining to parents at every stage of the IEP process where we're going next, especially around placement and services. Open up the conversation to hear parents' concerns, interests, thoughts, desires, weave that into your conversation when you ultimately make your offer, and document every bit of it in your notes. Because as I said, the United States Supreme Court said, courts, judges, lawyers, stand down. Where districts and professional educators hear parents' concerns, come with a response to that and their own view about what the offer is going to be and what the goals are going to be, and make it clear in the IEP following conversations and document the rationale in the IEP. I've had at least 3 hearings since Andrew F. where I prevailed because the district has taken a great deal of time to A, have the conversation, but document the rationale in that moment for parents, not later for a judge in a hearing. And it takes more time. It's can be very challenging if the conversations are challenging, but it's the thing I think we need to keep at the top of our minds going forward. And it's 3:30. So that kind of brings me to the end of what I wanted to say today. I hope it was some of it which you either wanted to hear, or if you didn't want to hear it, you're going to find it helpful. I hope you will.
Well, you do have some thank yous, and we all thank you so much for being our partner and friend to our county. For those of you that hung in there, thank you. And Jan, you're just fantastic always. We learn so much from you. So thank you, thank you, thank you for your time and all of your information. I'm going to pause our recording just for a minute.